Now, there's something here about retention of records. You can see that D's office will provide you with most of the official record. Your records are duplicates, and that's important unless you've taken substantive notes and have documents that should be included as part of the work product of the file. Again, the work product, though, is going to be protected under the exemption that's above in C1, the last bullet under C1 for deliberations and working papers. I would view that rather expansively to preclude production of, your initial thoughts, your first thoughts. And that's in keeping with the Supreme Court's view on FOIA. If you're not familiar, this last session of the General Assembly, there were a couple bills introduced to expand the I guess the susceptibility of records within the Office of the Executive Secretary to the public. And the court's a little bit skittish about that, but they certainly don't want judicial bodies or quasi-judicial bodies to have to reveal their impressions and thoughts of cases, and I think that's for good reasons as well.
Cameron, did any of those bills pass?
I'm sorry, Alex, go ahead.
Did any of those bills pass?
I believe, I have to double check again. I think there was a big conflict because the court passed what's called Part 11 of the rules. Most of what governs the bar is Part 6, but Part 11 was a change that the court made, which I think it cut off at the pass a lot of what the bills were seeking to make available. So I have to look at the nuances. What we were interested in was how it was going to affect us, and fortunately it's really not making a distinction because Part 11 didn't exclude us. The court tried to essentially exclude certain aspects of what would be available to the public, but they made it for the General District Court clerks, they made it for the OES, they made it available for certain other administrative agencies of the court, but not the bar. And I think they even included the Board of Bar Examiners. I have to confirm whether there's two bills. Well, there are a number of bills, honestly. One was by Delegate Simons, I believe, in Newport News, or Delegate Mullins in Newport News, and then the other one was Delegate, I think it was, I can't remember his last name, for Virginia Beach. It was a bipartisan bill, but it was aiming to get essentially at some of the administrative records of the court. And I'll have to get back to you on where it ended up, but there were many variations of it, and that's why I lost a little bit of track on it. But from our perspective, we comply with very narrow exceptions, with the ones pertaining to paragraph 13, with all of FOIA. So, from our perspective, we're going to continue to do what we've been doing.
Yeah,
Does that help at all?
Yeah, so nothing passed that changes what we would be doing or not doing as members of the disciplinary board.
Exactly. It really had more to do with the OES and the General District Court clerks, not the Circuit Court clerks, obviously, who are independently elected.
Hey, Cameron.
Yes.
Before you go on, I just noticed that Jamie is now recording this meeting, which none of us consented to.
Yeah. Well, that's an interesting point. So here we go down this ridiculous rabbit hole of the nuances of FOIA. Part of the reason we can do this meeting the way we're doing it right now is because the budget bill from this General Assembly included an amendment after COVID-19 really took off. Because if you all recall from press reports that there were all these public body meetings that were occurring that weren't, they weren't in keeping with the code. The code previously allows there to be electronic meetings, even under an emergency circumstance, and when the governor declares an emergency, but only for the purposes of addressing the emergency. So, for example, I came from Norfolk, where I practiced before I came up to Richmond. There was a report of the Norfolk City Council having a meeting, and on the agenda, it was an electronic meeting, very similar to what we're doing, or it might have even been just telephonically. And part of the agenda was to address whether the Costco could have a special use permit, right? So like the public open government folks were pretty frustrated by the fact that that the city government was shoehorning this issue, which had nothing to do with responding to COVID-19, into the exception because people couldn't get together. So there was a compromise reached, which was essentially we're going to allow meetings to go forward electronically without a quorum assembled. So that's really the hook in all of this, is that to use electronic communications, you have to have a quorum physically assembled. That's the way it was prior to the amendment to the budget bill. The budget bill made it so that you don't have to have a quorum of the public body physically assembled, and there's no restriction on what they can discuss. So we can hold this meeting. It doesn't have to be related to COVID-19, and we don't have to have a quorum in person. But to Sandy's point, one of the requirements under this budget bill was that you have to make the video, you have to post it online. You have to make it available to the public on your website. So one of the things that we're adapting to right now at the bar is how can we allow our public bodies, not all of the bar entities are public bodies, the disciplinary board is one. How can we make them be able to do their business without having to assemble people in Richmond or some other place, without having a restriction on what they can discuss? And the answer is to utilize this new law that was just passed. But we have to post it. We have to record it, and we could either record it or transcribe it. And frankly, it's cheaper to record than to transcribe. And then we have to post it to our website.
And my apologies, I forgot to start the recording in the beginning, and I just realized it, and I sent Jamie a message.
So will all of our hearings be recorded as well?
If so, they will have to be, if you're going to go forward with the hearing under essentially the I'm going to keep on calling it the budget bill, FOIA exemption. If we go under that, then they will have to be recorded. But yes,
that would be with regard to any hearings that are public, right? We wouldn't be recording an impairment hearing.
Impairment, right? Exactly, Yvonne. Exactly. Yep. So if we're going to take advantage of this new exception, now the question is, come what, August is the first date that we have hearings, right? Come August, it'll depend. Obviously, it's a decision for you all to make whether you want to meet in person or you want to proceed electronically, assuming the governor's declaration of emergency persists that long. Right now, the most recent executive order makes it go, it's an indefinite order. So the emergency will last presumably until August. The previous order only lasted until June 10th. And then, a couple days or maybe a week or two ago, he extended that to make it indefinite. I think it's by code or by Constitution, the order cannot extend beyond June 30th of 2021. So we have a lot of time if he chooses to allow it to go that far. If not, if he declares that the emergency is over on July 31st, then we don't have a choice. You can't do the hearing electronically. You'd have to assemble in person.
So this was going to be posted on the website?
Yes, this training has to be posted on the website in order for us to be able to utilize this. And
then what I noticed when it popped up on my screen was a recording is started. This meeting is being recorded. By joining, you are giving consent for this meeting to be recorded. And then it has like a line for a privacy policy. Is that something that the chair or whoever's leading this needs to let people know, or is that warning good enough for Virginia law?
So, well, from our purposes of this has to be a public meeting, right? Like if we were doing this in person, it would likewise be open to the public. The recording aspect is really just meant to allow that. So I don't know from I kind of hear what you're saying. Like there's always that concern about whether, it's a bilateral consent state or unilateral consent state and all that. But that would presumably only apply if we were trying to utilize this as evidence or something like that. I mean, I suppose if somebody wanted to sue the bar and say that, here's the exhibit, which is the video that was posted, and somebody could argue, well, I didn't give consent. I don't think that that would hold any water, given the fact that in order to hold the meeting in this format, we have to record it.
Okay, I'm sorry for interrupting.
No, that's quite all right. I think
Cameron, there was one other thing related to FOIA and the records that are subject to the exemption that we would most likely be dealing with as board members, which would be the email communications among board members. My understanding is that the bar's recommendation is that we have a header on top of our emails that indicates that the email is for deliberative purposes, so that it's, it becomes a little bit clearer when we have to respond to a FOIA request that these are records that do not have to be disclosed.
Yeah, I think that's an outstanding point. Thank you for bringing that up. It's very useful to make it clear that that what you're, when you're sifting through these things, because you're going to use some email account that, you're going to have either your personal, business on, or your actual legal practice. And it would be beneficial for a couple of perspectives. One, to sift what is related to the disciplinary board and what is not, and then also what pertained to a hearing that is essentially an exchange of ideas, or perhaps thoughts on a particular motion or objection, or if something gets presented at an agreed disposition, or the pre-hearing conference call, and there's an objection coming, and you want to pre-butt or bring that to the attention to the other members of the board, you would want to put that that's deliberative and it won't be subject to disclosure. The other thing to take some degree of solace in is the fact that before this goes out, it goes through me. Well, it goes through Stephanie, who will essentially just gather all this together, and then I'll take a look at it, and we'll make a determination whether it has to be disclosed. And there are exceptions, obviously, and we state those in response to the FOIA request that something's accepted if it is. So, but that's a useful way to help you discern between what is something subject to any kind of disclosure and what's frankly private or your personal business. Okay. Any other questions so far on the records? Okay, so let's talk about the meetings a little bit. The meetings are essentially like what we're doing right now, and some of the meeting requirements are even different from when I made this outline, given what has happened in the last 3 or 4 weeks with the budget bill. But one thing that hasn't changed is what constitutes a meeting, and this is an important one. 3 or more members of the public body, or a quorum, if a quorum is otherwise defined, constitutes a meeting of a public body. And the real threat and the harm to see here is, if you can imagine a school board, as obviously Yvonne worked with very closely, or a council or a board of supervisors, the harm the law seeks to avoid is, you go to a contentious meeting and there's a lot of public outcry, and then afterwards a few of the committee members or council members or what have you go in the parking lot and say, well, this is how we should resolve this. That's the concern that the law is trying to avoid, and that's the example that the FOIA Council always provides. And so as a result of that, when we email you, you'll often notice that we BCC members of the board, and that is so that we don't convene a meeting, because the thought is that, well, you're all going to exchange ideas and make a decision regarding the public or something as far as affecting the public, and it won't be open to anybody for any kind of input. So we always use the BCC line. I want to encourage everyone to do that. It really is important. I would just state that, from a legal perspective, there's some questions as to whether you're actually creating a meeting if you were to email each other, because there's a lack of synchronicity with regard to how quickly and how effectively you could communicate. That being said, our practice is just to BCC each other if you are a member of the public body. That does not apply to the staff. So me, Divita, and Vivian, for example, could email each other. That doesn't create a meeting. But if Reba, Alex, and Robin did, that would create a meeting. So you can get around that if you're emailing with us and you want to include others on the public body, just so they have some awareness of what's going on by BCCing them. But the goal is not to send emails to each other. Like Reba shouldn't send an email to Alex, Robin, and Sandy and just send it to herself and BCC, Alex, Robin, and Sandy, and just say, I think we should do that. That you shouldn't do. But if you wanted to, for example, I'm not trying to pick on you either, Reba, but if you wanted to email, a D about something, hey, D, I have concerns about this, but also make it clear to Alex and Robin and Sandy what's going on, that would be okay.
And so, Cameron, one other thing that has come up last year was that, sometimes board members get together for dinner, really just for the collegiality of it all, not to discuss tomorrow's docket. Is there any issues with that?
No, and I mean, I would certainly take the position that, if you're not, so long as you're not talking about the cases, just like any, judge, would not talk about cases with parties, for example. And I, interestingly, had that happen once with a federal judge who decided to talk about a case that he actually had under advisement, and it was a bench trial. And he talked about it with me and one of the litigants. And I was like, both of us scratched our heads after that. That's a rough analogy. I guess what I would say is that, as long as you're not talking about the case, then by all means, go out, have dinner, talk about your kids, talk about the weather, talk about, surviving COVID-19. It would be difficult, very far, socially distanced, of course, but yeah, that I don't see any problem with that, and we wouldn't seek to be the police of that kind of social interaction. And I think that really wraps it up. There are a lot of supporting materials in or supporting FOIA materials in the materials that Divita has provided you. So feel free to take a look at that. I didn't get into this business of FOIA until I joined the bar. And I will tell you that there's a lot of, it's very arcane. There are a lot of exceptions. There's a lot of nuance. But we try to be reasonable about it as well, and try to be sensible, reasonable, and help you get to what you need to. And my dog is just coming out. But that is all I have. If anybody has any questions on that, I'm happy to answer.
I have one more question. So, we get a lot of materials. Is it okay to destroy the materials once it's over? What's your recommendation on us saving our own documents?
Yeah, you can destroy them because, as we say in here, the ones that you get are duplicates. D will have the official records for production. Sorry, you're all hearing my dog. He has an Elizabethan collar on, and it's bothering him a lot. In any event, what you get are duplicates. D's got the official copy that can be provided in response to a FOIA request if it were needed. If you make substantive changes to something, it would be advisable to keep that. So if you have the only copy of it, keep it. But that still doesn't mean that we'd actually disclose it. It would likely be exempt under one of the FOIA exemptions, but we want to keep the record just so that we had it.
Thank you.
Yeah, okay. If there are no other questions, I will pass off the baton, but let me just say one other thing too, because I work with Dee in her roles as the clerk. This is unrelated to FOIA, but if there's anything that you have a concern about that, with respect to interactions with the parties or anything like that, please feel free to let me know. I am a lawyer. Dee has got way more knowledge than I do, but if you need any lawyer type perspective or concern that you have, feel free to reach out to me. I like to play arbiter, and Dee knows this very well, and Sandy knows this very well. I like to play arbiter between respondents counsel and bar counsel. I was a former prosecutor. You know, I have some concerns there, but I was also a former defense attorney. So I like to play it very down the middle from Dee's perspective. And we view this very much like you all are the judges, we're the clerk, and we're just going to reach out to both parties with whatever it is that you want. And time again, Dee can tell you this, I always just assess it from, well, what would a judge do in the case pertaining to the relationship between both the bar counsel and respondents counsel. So please keep that in mind. And if you have any questions, give me a call.
Thank you. Thank you very much. So I guess next we have a hearing. Oh no, Yvonne, overview of pre-hearing conference call.
When a case is set for a hearing before the disciplinary board, we have a number of things that happen prior to the hearing that typically one of the chairs gets involved in. And we have the chair, which right now is Sandy, and then we have two vice chairs, myself and Mike Beverly. And when a case is getting ready to go to hearing, one of the chairs, the chair who has been assigned to chair the panel itself, will hold a pre-hearing conference call with the parties and their representatives. And that occurs about, Dee, is it about 6 weeks before?
The pre-hearing conference call actually happens, it's normally the Wednesday prior to the hearing.
Wednesday before, okay.
About 10 days.
Right, and then before that, they also get a pre-hearing order, giving them some rules of the road for how they are to conduct themselves in connection with both the pre-hearing conference call as well as the hearing itself. And you see an example here of the pre-hearing order that will go out. That gives them a series of dates, deadlines by which they are to complete certain things. And probably the most significant of those are dates that relate to when they need to get their witness list in and when they need to get their exhibits in to the bar, to the clerk's office, so that everything is ready to go on the date of the hearing. And I will tell you that we do get a number of respondents who are not represented by counsel in these hearings, and we'll get to the pre-hearing conference call and the respondent has done absolutely nothing to comply with those deadlines and gets to the hearing with no witnesses on their witness list and no exhibits pre-filed. And that's always really unfortunate. It's one of the, if there was some way that you could communicate, it's really important for you to have an attorney. I'd love to be able to do that, but that's the way it happens sometimes. So going to the pre-hearing conference call, this, as Dee suggests, is shortly before the hearing itself, about a week before. And I would, if I were chairing, I would be on the call along with a member of the clerk's office. We would have a recorder going. We will not have a court reporter typically. And then we will have bar counsel, respondents counsel if the respondent has hired counsel, and then the respondent, him or herself. The first thing that we do, just as we do in any proceeding in these matters, is to confirm that there are no conflicts for presiding in the case, and then advise the respondent of his or her obligation to be truthful as we go through the conference call. Then we look at whether the deadlines have been met, and are there any issues that need to be resolved? At the pre-hearing conference call, we sometimes will take up motions for continuance. Other evidentiary type motions that one of the parties has raised. And we will explore whether there's an opportunity to reach some kind of agreed disposition. Obviously, if that is a possibility, we want to encourage the parties to do that if they can. And then we, of course, want to make sure that there is going to be plenty of time for the hearing to be presented within the time frame that we've reserved. Usually, we've just got 1 day on the docket, but we need to know if we might need more time. Also, if we've got, go ahead. Was there? Okay. If there are participants in the hearing that either of the parties believes is going to require some special accommodations, is there somebody who needs wheelchair access, anything that we might need to do to make sure that person participates, it's good to know that, and that's something that's explored during the pre-hearing conference call. At the end of the conference call, whatever the resolution of the call is, it will be followed up with a pre-hearing conference call order, which is signed by the chair later that day and will go out to the parties. And we've put up on the screen a template for what those orders look like. So I think that's it in a nutshell. Are there any questions?
Yes, Yvonne. Alex,
Yeah.
What's our authority to waive for lack of harm or lack of surprise these deadlines for exhibits, for instance, something everybody knows is going to be admitted or everybody has, but they didn't list it on the exhibit list, or a witness who the bar interviewed and is not surprised by the fact that this person is going to be testify but wasn't listed? Or is there not just what authority, but also is there sort of precedents that we use, or is it up to each panel to decide these situations?
Yeah, that's a good question. Our rules say that the chair on the pre-hearing conference call can make those decisions, but those decisions are subject to being overruled by the panel itself on the day of the hearing.
Okay.
And so if we were in a situation where, for example, the respondent wanted to introduce an exhibit that during the pre-hearing conference call, felt was entirely irrelevant and would simply be a waste of the panel's time to consider, and then we got to the hearing and the rest of the panel felt, well, no, we'd like to see this, then that would be susceptible of being overruled at that time.
And Alex, I think from if I listened to the question in a different way, I heard the question a different way. If we're at a hearing and Bar Counsel wants to move in an exhibit that they did not identify, it's up to the chair initially to say, well, why didn't you identify it, and then decide if there's prejudice that would attach if they're not allowed to use it. And then, of course, it would be subject to the panel overruling whatever the chair did. But I think it is an individual case-by-case basis.
Okay, that's what I thought, but I, not having perused the rules and preference before this training, that's why I asked the question. Thank you.
You're welcome.
I mean, I must say I've always preferred the general district court procedures that are a lot looser in these regards. So that's always been my preference. If there's no harm, let something in.
And I would say, Alex, that is typically how we handle evidence with the disciplinary board. I don't think that there is much that gets excluded. I think we kind of, default to allowing most of the stuff in and then deciding at the
Deciding
end
the weight.
whether we think it's important or not.
Right, deciding the weight, exactly.
Yep.
Yeah. Okay, thank you.
Well, I also think, though, like sometimes you have complicated financial cases that whichever side knows that they're going to need these bank records and they didn't exchange them or it wasn't on the list and there would be prejudice attached to allowing it into the other side, the board might not allow it in because the board is entitled to enforce its own orders. So I would just remind everybody of that too.
Yeah, case by case decision.
Yes. Yep. Is there any other questions before we move on to hearing procedure? No, hearing none. So under the hearing procedure agenda, and I don't know, we have on the computer the aggravating and mitigating factors. On your iPad will be the ABA standards, and I don't know, I'm holding mine up if you could see it. I don't know if Dee will be sending these out or they're just on the.
We got them.
Okay, good.
We got them last week or the week before.
Oh, good.
That's
Yes,
great.
they will.
So that's another thing that, you could be using to look at in preparation to kind of figure out what standards the ABA would impose. Of course, we're not bound by the standards, but the bar council always refers to the standards, generally speaking, as does respondents council. And they go through the aggravating and mitigating factors as far as the sanctions as to what should be considered when determining the sanction. And I'm not going to read them for you, but they're all listed there in your outline. And Yvonne, unless you have something to add or there's any questions.
All I was going to say is it's kind of, we're taking up the factors before we've really talked about what happened first. We wouldn't be considering the aggravating or mitigating factors until the panel had determined that there was a violation of the rules. So
that's right.
There first have to be a finding that there was a problem, and then it would be considering these factors as a way to determine what sanction would be appropriate to impose on the respondent as a result of the violation that the board has determined occurred.
That's right. And then up on your screen, you have the most frequently alleged violated rules. Yvonne, do you want to do this one?
Sure. We see, let's see, diligence, communications, 1.3, 1.4, 8.4C, conduct involving dishonesty, fraud, deceit, misrepresentation, crime, or deliberately wrongful act that reflects adversely on honesty, and then failing to deliver property or failing to return to the client money that belongs to the client. And I will say with 1.3 and 1.4, which are diligence and communication, if that's all there is, it's probably not going to get to the board. But I would say typically, if that's combined with other things, then you're looking at some serious misconduct, which is misconduct which would go to the board. Now, of course, sometimes we have somebody who has 5 different complaints that have been filed at the same time, all alleging lack of diligence and lack of communication, in which case it starts to look like a respondent who is not minding the store, and it is serious and something that the board needs to take up. Let's see. I would say probably the most serious ones that I have dealt with the 1.15 violations. That trust account issues are always, when those are happening, things have really gone off the tracks, and so those are treated with great seriousness.
And then what about the top 5 violations? Anything else on that?
Let's see. On the, let's see, we talked about the communication, keeping the client informed, diligence, protecting the client's interest on termination of representation. Yeah, that seems to be something that we would see more often than not in a litigation context where the attorney was involved at some point in the representation of the client in litigation, and then did not do what was appropriate to allow the client to be, like to note an appeal, or what would be necessary to preserve the client's interests, and having harmed the resulting in harm to the client as a consequence. Explaining the matter to the client to permit informed decision. I'm not sure. I'm trying to remember any cases that I've had that dealt with that. Have you had any of those?
Yeah, we've had them where it's to explain to informed decision, where it's actually really to even explain anything, where they're not telling the client exactly what's involved, and they're keeping them in the dark, and the client's not being part of that decision-making process. Those cases, the clients obviously come to the hearing to testify, but we've certainly had them. I've had a couple in the last year.
Mm-hmm. Yeah.
And then going on to the types of hearings, you have most of our hearings are public hearings. So just about every one that we're going to talk about is public. And the private is the impairment hearing, which we've talked a little bit about now, and also the show cause for an interim suspension for noncompliance with the subpoena ducis tecum. So you have your general misconduct hearing, which is what you're generally going to hear those types of cases, and you'll have all of the charges that are brought before you. Sorry, I'm playing with my screen to try and get out of the sunlight here. You'll get the certification from the district committee, and it will also outline the rules that have been alleged to have been violated. Then you have the reinstatement cases, which are also public hearings, and that's where a lawyer has been revoked and they're asking to be reinstated. The board actually is just issuing a recommendation to the Supreme Court, and then it's up to the Supreme Court whether or not to accept the recommendation of the board as to whether or not reinstatement should be granted. I've been waiting on one of our cases, Dee, for a year. I mean, I don't know, the Supreme Court hasn't decided it, but.
We have not received an order yet.
Yeah, so usually they turn them around pretty quickly, but for some reason that one's sitting in the Supreme Court. The reciprocal discipline, that's when you've been disciplined in Maryland or some other state, and then Virginia wants to impose the same discipline under our rules. Those hearings are usually heard on a Friday, and they come in with the violation and the certificate, the findings from the other state to come to Virginia with it, and then our counsel is asking for the same discipline to be imposed. Yvonne, you've had a few of those, haven't you?
I have, yeah, and I would say typically those hearings don't last terribly long, because you're not rehearing all the evidence again, because the other bar, the Maryland bar or the DC bar, has already gone through that process. So it's really a hearing in which the respondent has the opportunity to say, well, here's the reason why I don't think the disciplinary board for Virginia should be taking away my license or suspending my license. And he or she might then put on some evidence of, some, personal circumstances that are going on in the individual's life or something like that. But you're not retrying the case. And so those tend to be fairly quick hearings.
Yeah, the before, I don't know, was it last year or the year before, Cold struggled with rewriting the reciprocal rules because we had all kinds of issues as to whether or not, if the General District Court of Fairfax County said you're not allowed in my courtroom anymore, does that count for reciprocal proceedings? We had all kinds of issues, complex issues that came under the old rule. I think currently, though, they are moving quickly, and under 1324 capital C, the respondent, one of the claims they could prove is whether or not the imposition by the board of the same or equivalent discipline of the same proof would result in an injustice, or that the same conduct would not be grounds for disciplinary action or for the same or equivalent discipline in Virginia. It's up to the respondent to put that forward, though, within 14 days of his response to the proceeding. So the board also struggles sometimes with if the respondent misses that time period, but it's important just to be really aware of the rule and what has to be done when it comes in front of the board. I know Dee's office sent the latest rules out electronically, which is good because, I usually, again, I carry my rules of the Supreme Court, which God is like 1,000 pages now. So it's good to have those rules available to make sure that you're aware of what the respondent's required to do and what we're allowed to do under that rule. Yvonne, I'm going to turn it over to you for criminal appeals.
Okay. Yeah. So in addition to misconduct as a basis for disciplining a lawyer is subject to discipline if the lawyer has been convicted or pled guilty to a crime, and the term crime is specifically defined. It's an offense declared to be a felony by federal or state law, any kind of other federal or state offense that involves theft, fraud, forgery, extortion, bribery, or perjury, or an attempt, solicitation, or conspiracy to commit any of those. And like the reciprocal proceeding, this is a proceeding in which the respondent bears the burden. That is, that the respondent has to come forward and present reasons why he or she should not be disciplined. And then the bar responds to that with whatever the bar's evidence is, if any has been put on. But the onus is on the respondent to put forward evidence. I've had a number of these. In fact, I think the most recent one that I had, the respondent had been convicted in federal court of a number of felony counts in federal court, for which he had already served time and was now out, had finished his sentence, and the proceeding was before the disciplinary board was at a time when I think he was maybe in a halfway house or something. Anyway, and I was kind of anticipating that the board's response to that would be, this is somebody who should lose his license. But in fact, the result was that this respondent was given a suspension for the amount of time that he had served in federal prison. which is kind of an interesting result. But again, one of those things where after you determine that there is justification for taking some kind of disciplinary action against a respondent, then you go to the sanctions phase and consider additional evidence. And part of the evidence that we considered on that panel was what else this respondent had done in his very long career as a lawyer. And this attorney had no other discipline in like 45 years in practice. And that weighed heavily in the board's determination. So the fact that you're looking at an attorney who has been convicted of a crime does not necessarily mean that the attorney is going to lose his license or be suspended. But these are certainly serious cases, and unfortunately, we see a number of them.
And then with regard to the appeals, do you want to talk about that, Yvonne?
Sure. I haven't done any of those. So Sandy, maybe you could talk about that one.
Yeah, you get to, this is also a public hearing, and you proceed on the record that was made in the district committee and decide whether or not the sanction was appropriate.
Mm-hmm.
I think I did one my very first year, and I haven't seen many since then. Dee, do you get many of these?
We get very few. In the 3 years, we've had 2 in my 3 years here. So we get very few.
Yeah.
Okay, so then the next one is the expedited petition. This is also public. My understanding of the way this works is some bar counsel asks for an expedited hearing. The chair gets to decide whether or not it should be expedited, right, Divita?
That's correct.
And then once the chair decides whether or not to expedite it, then the clerk's office scrambles to get a panel set and have the hearing heard promptly. I think those usually work out at the end of the day when they do expedited. The ones I've seen for expedited either involved criminal acts or trust account violations, serious trust account violations that the bar council requests that the hearing be expedited. And I've only denied one request for an expedited petition. Then you have impairment. Impairment is our private proceedings, and if we're actually having a hearing in Richmond, we have everyone leave the courtroom during the impairment proceedings. Generally speaking, the respondent, if he or she doesn't have counsel, the board will appoint a guardian ad litem for him or her. And sometimes impairment comes up on bar counsel's petition where they're investigating misconduct and they think that it's really an impairment issue. What we've seen also at times is in a misconduct case where a respondent at the sanction phase wants to say impairment as a defense. And you really have to read the rules because they're two different animals here. And impairment as a defense to the misconduct doesn't fall within impairment under the rule for impairment. And the board does debate this topic, take it very seriously, and they have heated debates over it, at least the ones I've had, because the impairment wasn't pled and the bar council didn't have an opportunity to do what they wanted to do to investigate. Yvonne, have you had any other issues with it?
Yes. I mean, they were variations on what you just described, Sandy. I think it is very tempting for respondent and respondent's counsel to raise impairment related issues during the sanctions phase because, you know, it may be sort of a Hail Mary for them to, you know, to avoid the consequences of, you know, a revocation or a long-term suspension. But I think to Bar Counsel's point on these kinds of issues, if there is indeed an impairment, the Bar Counsel should have an opportunity to determine if there is evidence to support that earlier in the process. And by raising it for the first time at the sanctions phase, basically forecloses that opportunity. So I think it's certainly a problem, and I think the panels that I've been on have been very reluctant to accept evidence of impairment at that point in the process.
Okay. Next is RISA, shows how old I am. I know it as CRESPA, which is your Real Estate Act. It's a separate rules. It comes under the RISA Act or the regulations. I have never done one, and I hope to leave the board without ever having to do one.
We haven't had one. I looked to see when the last time, and it was about 9 or 10 years ago that there was.
Okay, well, I hope we'll keep our streak.
That's right. Interim suspension, Yvonne?
Yeah. We, as you all can imagine, the bar is involved in investigating a complaint when it first comes to the clerk's office, and part of their investigative process is to request records through subpoenas duces tecum, and by doing that, they are issuing orders that will, among other things, require the respondent to take certain actions, like turn over records or make him or herself available for interviews, that kind of thing. If the respondent has failed to comply with an order from the bar, from the clerk's office, from the disciplinary board, and has not met those obligations, the respondent can be summarily suspended, have his or her license suspended on an interim basis until the respondent complies with whatever the requirements are. Okay.
Yep, and then the next one, Yvonne?
Oh,
show cause non-compliance, public.
yeah. Here we go. Right. After a disciplinary board hearing has occurred, a sanction has been imposed on a lawyer to, that results in the suspension of the lawyer or revocation of the lawyer's license. The lawyer is required under the board's order to take a number of steps that are intended to make sure that the public is aware of what has occurred by virtue of the disciplinary board's action. And those requirements are to notify the clients of the disciplined lawyer that the lawyer is now suspended or has had his license revoked, and to let the courts and judges where the lawyer is practicing know. And the lawyer also is required to pay various costs associated with the disciplinary board's proceeding. If the lawyer has failed to meet those requirements, the board can issue a show cause in which the lawyer is required to come before the board again and put on evidence to show that he or she has met those requirements. And if the lawyer is unable to do so, the lawyer may be subject to additional disciplinary action.
And we do those, by the way. We have hearings on them. We had one recently where, while they're required to give notice in a particular way under the rules, we were just asking this respondent, well, if you have 5 cases, why didn't you email the courts? And no response.
Yeah.
So that's the 1329 failure to comply with terms as well. And then motions, Yvonne has had more motions than me. I mean, you've had cases where you've had considerable motions day practice, right?
Yeah. Yeah.
And how does that work?
Well, I'll tell you, the fact that I did have a couple cases where there was so much activity in motions has certainly caused me to question, how we want to go about doing it, because I think that they can really delay the proceedings significantly, and that's what I certainly found with these couple of matters that I was dealing with. And that becomes problematic, particularly if we've got 5 board members plus all the witnesses and, counsel and so forth, who are being delayed by the process if we're taking up motions on the day of the hearing. We try very hard to get motions taken care of at the pre-hearing conference call, if at all possible, but it sometimes doesn't happen that way. And I think one of the things that I would encourage us to look at as a board is, ways in which we can streamline the motions practice so that we are not dealing with those kinds of things on the day of the hearing as much as we can. But typically the kinds of things that, let's see, I've had motions to place records under seal. I've had motions for continuance. I've had motions, I'm trying to think, some other things. Mostly they've been motions for continuance where there have been arguments that there were, circumstances that the respondent couldn't have dealt with earlier that necessitated delaying the hearing. Those are difficult situations to deal with on the day of the hearing. Okay.
Before we move on, are there any questions about what we've talked about so far? Does anybody need to take a break? We only have a few more categories.
Mm-hmm. Robin sent a message. She had to step out of the meeting.
Okay. Will she be coming back?
Let me read real quick. No.
Okay. All right. So then we're just going to plow through, but if anyone wants to take a break, let us know. The next topic is pleading stipulated documents. And the first thing is encrypted emails. So what's going to happen is the clerk's office is going to send you an email that is through Microsoft, and they're going to tell you to sign in. And what it is I don't know how to explain this well, but you're going to get a message, and then what I do, okay, here's the encrypted message. To receive it, I always use a one-time passcode because I don't have an account. And when I get the one-time passcode, then Microsoft will send me an email giving me the passcode. I go back in and then I put that number in. I just block it and put it into my email, and then I get whatever the bar is sending me, and you could pull it down. It's pretty easy. Once in a while when the internet is slow or there might be a hiccup, I don't know, Yvonne, if you have it, that you're a member of Microsoft so you don't have to put this in, but that's how I always do it.
Alex, isn't that how you were getting your documents for your district committee cases?
I'm trying to remember. It's been less than a year. That's funny. I think that was the case. They would come over electronically.
Yeah.
And I had to put in some sort of Often, though, I remember just opening them up.
Oh, okay.
I don't have a good head for technology, so I just try to do what I have to do at the time, and then I tend to forget it.
Okay.
So I'm not much use.
Yeah, and if you have an issue, you certainly call Dee's office because they're really good at helping us get through that.
Sure.
And then SharePoint, that's the link that we used for this meeting. And it's instead of Dropbox, and I think it's wonderful. I have not had problems with it since we started using it. And you don't need to open an account or anything with it. So that's a really good change, I think, that the bar has made. And then the third thing is the tablets. At the day of the hearing, you'll receive an iPad where all of the information is on the iPad. All of the pleadings, the rules, the ABA standards, the case law summary that's up to date, the disciplinary board handbook in paragraph 13, and a legal dictionary. When I chair a panel, I usually print mine only because it's easier for me than going through the iPad, and I like to take notes. But it's really good because you don't have to carry all of your stuff to the hearing with you. And I would suggest if you have questions or things as you review it, you either jot it down on a separate pad or maybe print the pages you're concerned about, or when you get it, you'll have your bookmarks and just know your bookmarks that you could refer to it when you're on your iPad. And Dee is going to be able to help us figure out, if we're doing this electronically, how we're going to be able to show things on the computer, just like she's showing it now. And she and I talked about it before this meeting, and we agreed she's going to be the controller of it, because I think, like on my screen right now, I could request control. I don't want anybody to request control, at least not initially. Dee, do you have anything you want to add?
Nope, that's it. Yeah, and you're right. At this point, I could give you control, and you could move. I'm giving you control right now. You can move your mouse around, and it would show. You would be able to take control of the document.
Okay, and the other thing, and Cameron, I don't know if you know this or Jamie. I know, like on other applications, I could record these meetings, and it would show that I'm recording it. I couldn't figure that out when Dee and I were practicing. Is it only Dee who's allowed to record?
I don't know that I know that answer, Jamie. I would defer to you if you're paying. Looks like you're listening.
Yeah, I was listening. So if you look in your little toolbar in the middle where it says more actions, it's 3 ellipses. There should be a option for start recording. Y'all see that?
No.
Okay. You are in the menu bar with the camera and the microphone and such?
Well, I was, but I seem to be out of it now.
Hey, Sandy, you know how to mute your line? Did you do that before?
Yeah.
So it's
I
in
got
that
it.
same.
Okay, I'm there. I got it.
And do you see the stop recording?
I have show device settings, enter full screen, turn on live captions, turn on incoming video, turn off incoming video. That's all I have as a choice under those 3 dots.
Okay, so it may be guests outside of the state bar cannot start that.
Okay, well, I'm good with that. I was just curious if that's the rule.
Yeah, and I haven't dealt with that with people outside, so that's why I wanted you to look and verify that was there or was not there.
Okay, thank you. Next we have starting time, Yvonne. Anything?
Yeah. Right. Our meetings, our hearings for the disciplinary board start, as we already talked about, fourth Friday is typically when we do those hearings, and the hearings start at 9 o'clock sharp. But it is very important for us to be there in advance so that we can start right at 9 o'clock. My recommendation is that you arrive at the hearing location somewhere in the neighborhood of a half an hour beforehand, so you can put your stuff down, go into the deliberation room where you're going to see your other panel members. Make sure that, everybody's got all their materials ready to go, and you are not in a position of delaying the hearing. We don't want to do that.
And then affirmation of no conflicts.
Yeah. Here we've got the disqualifying factors that Ned Davis put together some years ago. They still apply. They're the same disqualifying factors that you would have used to consider any district committee cases that you were considering. And as we talked about that briefly a little while ago, but I think most of it's pretty straightforward. Obviously, the bar community at times can seem very small and very incestuous. We know a lot of folks over the years, and so we're going to see people before the disciplinary board that we may know, but that is not necessarily a reason for needing to disqualify ourselves. Instead, you should be looking at these guidelines for making that determination.
And questions from the panel. Yvonne?
Oh, I'm sorry. Questions from the panel. Where are we?
10.
Okay. When we are in the hearing, and Sandy made a good point about taking good notes. It is important for all of us to be engaged with the hearing, to be listening carefully, and when we are engaged, we are also going to be asking questions. And I think that's an important way that we reflect to the respondent and the bar participants that we are taking this very seriously. After we have a witness testify and the witness has had an opportunity to be cross-examined, then the floor is turned over to the panel members to ask questions of the witness, and that's your opportunity to delve into anything that you feel needs further explanation. And I think that's when it's really helpful to have made some notes as you've gone along, whether it's while you were reviewing the documents prior to the hearing or while you were listening to the testimony. Obviously, because we are in the role of the decision maker, all of the concerns that we would have about showing appropriate decorum is important to consider and think about as you are communicating with the witness in your questioning, to be professional at all times in the way that you are communicating with them.
And usually we ask before the witness leaves the stand, I'll say, are there any questions from the panel? Start from the left or the right and just let you ask questions if you have questions. Mm-hmm. So then conversations on entering and leaving the courtroom and decorum, Yvonne?
Yeah. When just as you would expect a judge coming in and out of the courtroom not to give high fives as he's coming in with the folks, that kind of behavior would not be appropriate, and it would not be appropriate for members of the disciplinary board coming onto the bench to engage in similar behavior. I think one of the things that I was conscious of, I was coming into a hearing one day, and I saw a member of our bar staff who I had not seen for a while, and I was just about to say, hi, so-and-so, because I hadn't seen this person and was quite glad to see her. And then I thought to myself, no, that's not what you want to be doing as you're walking into the hearing. you want to give the appearance that you are, impartial, and that's the role that we have when we are serving as disciplinary board members.
And then telephone conference hearing and agreed disposition.
Yeah. We have the ability, when the parties have worked out something that we refer to as an agreed disposition, to resolve the case without going to a full-blown hearing. And in those agreed disposition hearings, we consider them by conference call. So we would be doing it similar to the way we're doing this, except that we would not be on a video call. It would simply be a telephone conference call. And
we all did those on district committee.
Okay, right. And so you would see both the certification, that is the allegations of wrongdoing that come from the bar, and you would see the proposed disposition, which would say, a 1-year suspension, or, whatever they had agreed on. At the beginning of the conference call, we would go through the same process that we would at the beginning of a hearing. That is, to introduce the hearing, the participants, the members of the panel, and it would be a panel just like you would have a panel for a disciplinary board hearing in person. There would be 5 members, one of whom would be a lay member, and each of them would be introduced, and they would state whether or not they had a conflict that would preclude them from hearing the case. At that point, the Bar Council would present the case in a summary fashion to the disciplinary board panel for its consideration, and there would be an opportunity following Bar Council's presentation for the respondent to add anything he or she wanted to share with the panel. After that occurs, the bar has the ability to put the 5 members of the board panel in a private room for deliberation. And during the deliberation, the board members would then consider whether or not the proposed disposition of the disciplinary matter in the way that the parties had agreed to was something that the board approved of. As Sandy pointed out a little while ago, this is not a rubber stamp. This is something that the panel could reject, and if it rejected the proposal, then the matter would go to hearing, in person, unless the parties were able to come up with some other resolution that ultimately got approved. But I would say that more often than not, the panel, after hearing the proposed disposition, approves it, and after the panel has finished its deliberation, decides what it's going to do, we come back into a full meeting with everybody participating, and announce the chair announces the decision. Assuming that the panel agrees, I apologize for my dog. Assuming that the panel agrees with the proposed disposition, an order is then entered that day, which indicates that the agreed disposition has been accepted, and the disposition and the discipline is imposed, usually starting that very day.
Thank you. I'm sorry, I was trying to figure out if I could send a chat to Cameron to ask him if he was going to be Karen today, but now I'm kind of stuck in this screen, so give me a second to try and figure out how to get out of it. If anybody knows, I'm happy to.
There he is.
Sandra, did you want me to talk about the order writing?
Did we lose her?
Yeah, I don't know. I don't think
see her.
I think she just might have turned off her camera.
Hello.
Yep, we can hear you.
Okay. Hi. Sorry about that. I was trying to see if I could have a private chat with Cameron, but this Teams is not as easy for me as Zoom or the other one. So the next part, really, Alex, although it applies to you and Reba, but more to you and Robin, of course, lawyers are required to write the opinions. And you see the symbol on the agenda that you'll know if it's next to your name if you're the order writer. And that's when it really becomes really important that you take really good notes and you're able to do it. I think, Alex, you're probably one of the first people who did the writing sample for your slot, right?
I don't know when.
Yeah.
I don't know if I was one of the first. I did do it. It wasn't that hard to.
Well, it must have been pretty good because you got selected.
Yeah.
Yeah.
So it's really important this is the most important part of our job, I guess, second to hearing all of the evidence. So Cameron, I was asking if you wanted to do presentation on order writing, or do you want me to just keep going?
Well, particularly because of what you have identified with Alex's experience in the writing sample in particular, his individual experience was particularly good, and he picked up on a lot of the nuances, and it was a really good screening process. So I don't think we need to belabor this too much, but it again, we implemented that to ensure that these do's and don'ts and the important things of writing orders for review by the Supreme Court are adhered to and are followed, because the worst thing that we can have is a record that's devoid of really analysis. And I think that's what, if Karen were here, she would say that as well. Too often we found ourselves in the position where somebody would state a fact and then state the conclusion without drawing the link between them. And that's why we really had to implement the writing sample process to ensure that we were establishing a bedrock analysis for appellate review.
Right, and that's, I think that's the important part of this, is that our opinions go right to the Supreme Court. There have been cases where they've been reversed. For really what happened for a while was that you'd get the certification and the board would just kind of adopt the certification without tying in the testimony and the evidence that they heard. So it's really, really important that the order writer pay really good attention. But also, I will tell you that it's important that you pay attention and write good notes, because sometimes other members of the panel or the other order writer, you might not agree with the facts. And so we might have to have a discussion as to really what the facts were. And if there's an issue, then we might have to order a transcript to make sure that our order is clear. The Nicholas Smith memorandum order, which is one of our model orders for misconduct, and D makes available whatever you might need. But this is sort of our model that's a really good order that should be looked at when writing any of your misconduct cases. And it's important that when you're doing it, that you do address any pre-hearing orders from the board, the motions, continuances, and the exhibits that were, admitted into evidence. And you really need to go through. And a lot of times what you'll see when you're doing these cases is we might find that they violated 8.4A, but not 8.4B. So the order has to be really specific in what the findings are. What we do with regard to circulation, and Dee and I were just talked about this, you're supposed to on your emails put confidential, deliberate, and privileged. So Alex, if I was your chair, what I asked the board, my board panels to do is, if you're writing it, if you would get it circulated to everybody, I ask that you not copy the clerk's office, that the board then, the panel then weighs in using track changes. If they know how to use track changes, if they don't, I try and teach them at the hearing because it's really simple. Just copying all of the board members. A lot of time panel members will just do emails, which is also fine, but it's a little harder for the writer to see what the changes are. And then the writer decides, possibly after the panel, the chair weighs in as to whether or not those changes are agreed to or not agreed to. The chair gets the ultimate decision on it because the chair's the one deciding it. I'll tell you, I've rewritten orders, and I take the position, and I don't know if Yvonne does or not, but if I'm rewriting an order, I'm not circulating it to the panel because at this point I've given the panel the right to weigh in, and I've rewritten it to meet the evidence that I deemed should come into that order. We put case law in it. We put ABA findings in it if we need to, if we want to make that in the sanctions phase. But I tell people it's important that you think about it like, you know, you're going to the Supremes. We don't want to get reversed. So even though it might be me signing it, it's the panel. And you have to do the whole misconduct piece and then the sanctions piece. And then the other big important part, which we announced right at the hearing, is when does the sanction become effective? The policy of the board is the sanction becomes effective the date of the hearing, and the respondent is told that the day that it's effective today. Sometimes you'll hear argument as to why it should be delayed. I've never granted it. I don't know if Yvonne has.
I can't think of the time that I have. I've certainly seen, you know, requests for us to delay it, but I don't recall that we ever have on my panels.
The times you see it is, you know, if you have somebody who has a busy practice that just can't wind it all down and, you know, immediately, or you feel that it's going to prejudice the public if you impose that sanction immediately, if it's a suspension, especially. So those are the things the board takes into consideration, but the general policy of the board is the sanction is effective the date of the hearing, the date it's announced. Again, we do have dissenting opinions, so you're certainly entitled to do that. I've seen it a couple times since I've been doing this. Go ahead.
I was just going to say, and I have done it, and I had a lay member who was of the same mind, and my view was, we never want to put our lay members in a position of having to write dissenting opinion, but if they are dissenting, we want to offer our services, whether we join them or not. One of the attorneys on the panel should be helping to craft a dissenting opinion for any lay member who is dissenting.
Right. And the lay member's entitled to dissent.
Yes.
And then collection of board orders, I'm not sure what that is.
That's just something that we provide to all of the board members. It's an example of all types of orders. So if you're the order writer for, say, a criminal matter, we will send you 3 or 4 samples of those orders. So we just have a collection of orders for all types of hearings that we will provide to the board members to use as a resource.
Yeah, and Alex, the other thing I want to say is that there's at the end of all these orders, it says, you know, pursuant to paragraph 13F, you're required to do X, Y, and Z. Those paragraphs, Divita and her staff put on all that information as to what they're required to do. We don't necessarily put that in ourselves because she knows what's required, and she has the wording that goes right into the order. And she has it up on the screen there. So are there any questions, Alex or Reba, on what we've talked about? I know we've talked about a lot, and Alex, I don't think initially you'll get assigned to order writing, but you never know.
We'll give him a little bit of time before we assign him as an order writer. I normally try to let a panel member sit at least twice before I assign them an order writing responsibility.
And it is It is the board's policy, I guess, that Dee's office likes to get these orders back within how many days, Dee?
We like to have it back within 2 weeks, have it back and signed within 2 weeks from the hearing.
Right. Sometimes that happens. We all strive for that. Sometimes it doesn't, but that's the goal. So as chair, I usually follow up with somebody, you know, midweek of the first week. How's it going? Or do you need help? Because then Dee's going to start nagging me, and I don't like being nagged. So I nag you.
I nag you nicely.
You definitely nag me nicely.
One thing I was going to say, and this is more for Reba, although you are not going to have responsibility for writing the orders, it's still very important to weigh in as these orders are being circulated in draft form on anything that is, you know, inconsistent with, you know, what you recall or what you think is important. We need to hear from all of the members on the panel. So don't hesitate.
Thank you. And Divita, I was going to ask you, you said you gave samples to board members. Now, is that to the person writing the order, or, you know, it would probably be beneficial for me to see a good example?
It'll be included in with the materials that we're going to distribute to everyone in July, but yeah, you'll be provided with a copy of them as well, just for your resource. It's a resource for all board members.
Okay, thank you.
And I'll tell you the other thing, Reba and Alex, we have lay members who are, I view as excellent writers. I mean, so, you know, one of them in particular who I always like having on my panels, because she's like an English teacher and she used to go through and say, Sandy, you should have commas here or semicolon, and she's great. I don't take offense at it. I don't know how other people do, but
No.
any kind of editing like that is
that.
also appreciated.
Yeah.
So,
Thank you.
all right. Well, if there's nothing else, Cameron, anything you'd like to add?
I just have one question.
Okay.
Do we get CLE credit for this morning?
No, we don't. We've often talked about it. We wish.
Darn.
But that's actually the one thing I was going to say is, in particular for Alex, if you're thinking about that CLE, I think you were there when Justice Millett did what he talked about, serving in a quasi-judicial role. And he talked a little bit, too, about the order writing process and the deference to fact-finding by, you know, legal conclusions. And that's the only other thing I would point out. But yeah, that was it. So.
And I think the outline was in here. I just kind of went over it.
Yeah, all the material.
Yeah.
Well,
All right, Alex, Reba, anything else?
No, thank you very much.
You're welcome. Dee, anything you'd like to add that we just didn't cover?
Nope, that's it.
All right, thank you guys very much. I think this worked out well.
Thank
Thank
you.
you very
Thank
much.
you all for being our guinea pig for the first time. We appreciate it.
I got to
We would
figure out this
never
chat,
know.
though.
All right.
Thank you, folks.
Take care.
Bye.
Bye.
Bye.